Good morning, everybody. Thanks for joining us. We're just going to give a minute or two for people to file in, and then we'll go ahead and get started. Well, I think it's a good time to get started. It looks like we're settling in on a great number of participants here. Good morning, everybody, and welcome to the University of Pittsburgh School of Law and the 29th McLean Lecture on World Law. I'm Haider Hammoudi. I'm the Vice Dean of the Law School. Really honored to be here and to open this program to open the McLean program. The McLean Lecture is the law school's premier lecture on international legal matters. It's really the one that CILE focuses on, and we've had such wonderful guests over the years, over the 29 years of its existence. It includes two judges, and this year certainly no exception. Important to say, we've had two judges of the International Court of Justice. We've had members of the Nuremberg prosecution team, the attorneys general, former attorneys general, both the United States and Canada, the Solicitor General of Australia, the president judge of the ICTY, the Criminal Tribunal for the former Yugoslavia, and the list really goes on and on. And a great deal of thanks to both Professor Brand and Professor Katubi from the CILE, the Center of International Legal Education, here at Pitt Law for arranging this and for everything that they do. CILE is really one of the crown jewels of our law school. It was established in 1995, and so it's been in existence for just over 25 years now. It's where we house all of the wonderful international and comparative work that we do. We are renowned in the field, or we're well known in the field, and it's all because of the work that CILE does. It's the home to our LLM program, as well as a burgeoning SJD program. And we've been able to create connections and partnerships across the world with universities and law schools across the world through those programs. We've deeply been engaged in around the world through CILE. And in fact, from a personal level, I've benefited a great deal from CILE. In fact, the first Pitt professor that I met while I was still a candidate at Pitt Law was Professor Brand, and it was in Doha in Qatar. We were there for a conference on commercial law, and the VIS. I believe Professor Brand was there for the VIS pre-moot as well, and we had an opportunity to meet. So it's really been a wonderful personal and professional opportunity for me, and it's, as I say, it's really been a crown jewel for the University of Pittsburgh School of Law. We're really pleased that this year's McLean Lecture coincides with the Middle East VIS pre-moot training sessions. And that program, as I say, it's also longstanding. It's been co-sponsored both by CILE as well as the Commerce Department's U.S. Commerce Department's Commercial Law Development Program, and the Bahrain Chamber of Dispute Resolution, and then the Royal University for Women in Bahrain as well. And it represents the beginning of our move back to in-person programs as we begin to come out of the COVID pandemic. For those of you unaware, the VIS is the largest student-run international competition, at least in private international law, alongside the Jessup and public international law. And there are a number of pre-moots that Pitt Law has been leading and managing, one of them in the Middle East and really around the world. We've been really, really happy with the work that has been done there, and it's been doing nothing but expanding. Another wonderful example of the great work that CILE does. And it's particularly appropriate that this year's lecture, Professor Professor Jan Paulsen is speaking on international arbitration and its important role in international legal developments. We're really honored to have him with us. So with that introduction, let me turn it over to the academic director of the Center of International Legal Education, Professor Ron Brand, a friend and a mentor, and let him take over from here.
You're muted, Ron.
Thank you, Dean Hammoudi. And I want to welcome everyone on behalf of the Center for International Legal Education to this, the 29th McLean Lecture on World Law. As Dean Hammoudi indicated, this is the premier lecture on international matters at the University of Pittsburgh School of Law, and it's designed to reach an audience that's not just in the law school, but beyond the law school. It honors Mac McLean. Mac was a founder and active member of the World Federalists Association, both in Pittsburgh and on a global level. That organization was established after World War II to promote the rule of law globally. Max was also a vibrant part of the Pittsburgh international community and was dedicated to the idea that the expansion of the rule of law and of the creation of an international legal system was the only way to ensure lasting peace and justice for the world. That is a goal that today is being sorely tested. The McLean Lecture topics have included the work of the ICJ, the Nuremberg War Crimes Tribunal, the International Criminal Court, national security and intelligence matters, private international law, international environmental law. And this year, as Dean Hammoudi said, it coincides with the 12th annual Middle East VIS International Commercial Arbitration Training and Pre-Moot. We had planned to host the event at the Royal University for Women campus in Bahrain. Circumstances intervened, and we are again fully virtual for the lecture this year. But we are very pleased to have this year's speaker with us to bring the McLean Lecture really into connection with the work we have done in Bahrain with RUW, with CLDP, and with BCDR, a process that really began at that session in Doha that Dean Hammoudi mentioned. Because it was that trip that planted the seeds with the Commercial Law Development Program and allowed CILE to cooperate in this process. So without more, I'm pleased to welcome the newest member of our CILE staff, our Executive Director, Professor Charles Kotubi, to introduce our very special speaker and this year's lecturer.
Thanks, Professor Brand. It's really an honor to introduce Jan. I've known Jan for almost 15 years as an arbitrator, as a scholar, and as a friend. And I want to introduce him with two quick anecdotes, if I may. I recall back the first time I met Jan. I was a young associate at a large law firm working on an investment arbitration, and we needed an expert in the concept of denial of justice. And Jan had just written his seminal book on the topic a few years prior. So we retained him as our legal expert. And as an associate, I had the wonderful job of reading everything Jan had written up to that point in time, every article, every award, every public speech. And I can honestly say it was the best few weeks of my young legal career. It was at that point that I realized that I really wanted to be in this field. And that it was the first clue that I really wanted to be a scholar as well. Jan's work tracks the arc of international arbitration over the past 3 decades. I mean, it's helped build the infrastructure of international commercial and treaty arbitration. And he hasn't shied away from criticizing elements as well, which is wonderful. For my students, required reading on the first day of class is his article, International Arbitration is Not Arbitration, and Arbitration in 3 Dimensions. And if anyone questions the why international arbitration is so important, I would recommend to you his speech given, I think it was in 2007 or 2008 on Enclaves of Justice. It's just required reading. But for all his stature, Jan has also been very generous with this time as well. I recall when I was getting ready to publish my co-authored book on general principles in 2017, we asked Jan to read an early copy, and And he read the whole thing and gave us very helpful comments. And I remember one comment, and Jan's going to smile at this. It was in our section on abuse of rights. I think he wrote in the margins, this is exactly wrong, but I enjoyed reading it nevertheless. And I remember a few years later, Jan published his book on abuse of rights. And I really liked seeing exactly why I was wrong across several pages in that book. But I've since quoted his book at length as counsel and a scholar. So enough anecdotes, time for the introduction. Professor Paulsen has been a sole president and party-appointed arbitrator in countless international cases. He's been an advocate, counsel, and expert in many more. He has been a partner at major law firms and one of the founding members of the leading arbitration specialist firm, Three Crowns. He's based in Bahrain. He's a professor at Miami. And he's really the first true arbitration specialist that we've had for the McLean lecture. So with that, Pitt Law and CILE are really proud to welcome Jan Paulsen today.
Thank you very much, Chuck, for that undeservedly generous introduction. I'm very pleased to be with you today, but upset at the fact that I am not physically in Bahrain. I live in Bahrain, and I have not been outside the Gulf for 2.5 years, and this is the very week when I was called away, and I'm speaking to you today from London. I live in Sar, and my office is in Jaffa, or Adliya actually, in Bahrain, and this is a good time of the year when you enjoy being there, and I would have liked to be with those who are actually down there now, but so be it. Today, I'm going to ask you to reflect with me on some fundamental concepts of international arbitration. And I hope you bear with me as I speak to you without any notes, just some thoughts I invite you to consider about what happens to the ideal of international arbitration when it meets some aspects of reality. And it occurred to me that to this extent, it's a little bit like democracy. It's impossible to be against democracy. I mean, democracy means rule by people, and I guess we want people to rule themselves. But when you think of how this quality of democracy has been appropriated by all kinds of people, including all those who ran the satellites of the USSR, in the decades following World War II, and that the German Democratic Republic was, of course, run by people, and they call themselves democratic, and they insisted on that. It's actually part of their name, but that was East Germany, a country from which people risked their lives to escape because it was a police state where, in fact, it was considered that citizens were the property of the state, and the state was totalitarian and could do with it what it wished. So the ideal of democracy there wasn't quite, was the opposite of what one would wish for. And perhaps even all of us sometimes are distrustful of democracy. Sometimes you think about what you can see on YouTube. Sometimes somebody with a microphone walks up and down the streets asking people questions to see what funny answers they give to various things. And not so long ago, I saw this happening, and somebody showing people a very large map of the world with all the borders drawn, but no names of countries, and asked people to identify one country. And some people can't actually do that. And you think to yourself, that person surely should not be allowed to vote for who is going to run affairs, but that's difficult to do. When Athenian democracy began, I suppose the slaves did not have the right to vote, and I suppose women didn't have the right to vote, and we can all agree that that wasn't very good. I think in the United States, much later, I think to a certain period in the United States, in order to vote, you had to be a person of apart from being male, you had to be somebody who owned some property to show that you had a stake in the Commonwealth, and else, if not, you wouldn't be allowed to vote. So there's some tensions in this idea of democracy. what should be the age when you can vote? Is 16 low? Is 18 low enough? What if 18 is okay? And 18-year-olds sometimes, when we are 18, we sometimes do some foolish things. But if that's okay, why not 16? Why not 5 years old? I mean, those people have a longer life in front of them, and maybe they should be given the right to vote. And yet we make these determinations that isn't so. So there's a lot to the exercise of following one of our ideals when we actually get into reality. Like democracy, the idea of arbitration is fabulous. We get away from the impersonal meting out of justice, and we come close to justice. We actually identify the people who will be our judges, and we do it on the basis of our trust in them. And therefore, the decision they make will be something which we know in advance that we will accept, even if we are disappointed and think it wasn't right. Probably we're wrong and they're right because we trust them so much that they know better than we do. Well, that's a wonderful thing to think of arbitration as justice with proximity and with never having to worry about execution of the decisions of arbitrators, because they are held in such trust that their decisions will be accepted even if it's not quite what we were hoping for. That's the ideal, and if that's the ideal we have in mind, it's a wonderful one. However, it tends to run into trouble as it meets reality, and sometimes arbitrants, as I call litigants, like celebrants, arbitrants are very disappointed, and they think that there's something about the process. Well, they start with the outcome. The disappointing outcome they perceive, they convince themselves, rightly or wrongly, had something to do with there being something wrong with the process. And so let's think a little bit about that collision between the ideal of the thing and what happens when it encounters some reality. Sometimes I use the expression that it is very easy to love a beautiful child. But loving a beautiful child is not a test of love. It's easy to love a child who's polite, follows your advice, and gets good marks in school, and is commended by everybody. But what happens when your child gets into trouble and is disobedient and runs with the wrong crowd, does everything wrong? It's less easy to love that child. So let's apply that to arbitration. I'll give you an example. Now, the beholder of arbitration, I will imagine an Italian judge, and I'll tell you why. This has to do with the recognition of arbitral awards. And as I hope many of those who listen to me, I'm aware today that there are probably some people who know a lot about arbitration and others who know less. So I'm trying to bridge that range somehow by not being too complicated, but still say some things that may be of interest even to those who know quite a lot about arbitration. Those who know about arbitration are very familiar with the New York Convention, actually the United Nations Convention on the Recognition and Enforcement of Arbitral Awards. It's actually it's a misnomer. It's a convention on the recognition and enforcement of arbitral agreements. That is to say, the acceptance that if you have agreed to arbitration, the case will not be heard in courts. So there's the enforcement of the arbitral agreement, plus the enforcement of what happens later on when the arbitrator has decided. That was a huge achievement in the world, the New York Convention. And I suppose when the Secretary General of the United Nations commended that convention for signature to the various states, it came out of a feeling of idealism. And when the various nation states started signing and ratified the convention, that was also born of a feeling that this was something very worthwhile that should be that should be adopted. Now things start to happen, and I'm going to talk a little bit about what I imagine the quandary of Italian judges, because if you look at the early reports of actual cases that were rendered under the New York Convention, there, for some reason, there was an awful lot of them that came from Italy. And I once read through the developments in Italy. And this is what I imagine thinking about the difficulties that Italian judges had to assimilate this new thing. And you will learn something by reflecting on the fact that all the first decisions, this will never happen again under the New York Convention. All the first decisions that come under the New York Convention in a given country will be decisions that come to the court of first instance. There is no prior case law under the New York Convention, so this is new. So we have a judgment, an arbitral award, which is brought for enforcement in Italy. So we can assume that this means that there is an Italian party which has agreed to arbitration, but once the arbitration occurred and it lost, that party is so unhappy about the award that it refuses to enforce it. And now it's brought for enforcement. Where? To Italy, because that's the place where the respondent has assets, sort of a typical situation. And now it comes to Italy. And as we start this adventure under the New York Convention, the first case will come before a first instance jurisdiction. And that might be a single judge sitting in a small town somewhere in Italy who's never heard of the New York Convention. And a fancy lawyer comes in who does this international stuff and wants to, and is bringing this suit for the enforcement of an award rendered in some other country against the only important corporation active internationally in his town, which employs half of the population of that town and now has lost a significant amount of money in a case from abroad. And the judge is puzzled. Most of the time he is doing neighborhood squabbles and looking at people's traffic fines or what have you, and international stuff doesn't come up very often. And to the extent that he remembers, his legal studies might not have touched on international arbitration at all. But the fancy lawyer for the foreign party tells him this is a new thing now. Italy has signed the New York Convention, and like it or not, Italian parties have to accept and abide by the results of the arbitration. And look, I'll show you right here. This is how the Italian parliament ratified the treaty. It's the law of the land. So the judge says, okay, it seems that you're right. Let's have a look at this child. And he will discover a very ugly child. There were 3 arbitrators. They rendered a decision. They actually could not agree, all 3 of them, so there was a dissenting opinion. 2 arbitrators were not Italian. 1 was Italian. The Italian did not agree with the decision of the 2 others, so this is a decision that's imposed on the Italian arbitrator. Well, these things can happen. But, well, let's see. Let's actually look at the award. The Italian judge is used to awards being written in a particular way. And he notices, by the way, the contract says there should be an international arbitration, but the applicable law is Italian law. And this award is not written in Italian. It's been translated for me, but I don't know how good the translation is. I know English a little bit. I have a look at it. And I just have to say, this thing, just looking at it, is written in a way which no Italian judge in history would ever write an award in this form and with this type of reasoning. And it applies Italian law in a way that makes no sense to me at all. This is very, very ugly. And then he looks at the dissenting opinion. And oh, this is how you write a proper judgment. And this is the kind of an award I would be rendering if I were an arbitrator. This award is for quite a large amount of money, and it's really going to harm the interests of the major employer of my city. You see where I'm going? This is not a lovely experience to deal with the ideal of international arbitration, which seemed so great at the inception. This is the test. Not surprisingly, and this is just to understand the objective circumstances of judges of the first instance who see this, and yesterday they were doing something completely domestic, and tomorrow they'll be doing something entirely different, and today they get this thing, and you know, they will strain to find a reason to invalidate something which seems to them to be so wrong. They're told by the smart international lawyer who's presenting the case that you don't review the findings of international arbitrator. The Italian party agreed to this, and therefore the thing is binding, and the fact that anybody else disagrees with it is neither here nor there. There was no fraud in the arbitration, and there were 3 arbitrators, and they're allowed to apply Italian law, and they're not required to draft their decision in Italian or in the form that an Italian judge would do it. And you just have to enforce it, and the judge might just really find a way somehow to reject the award. Now, the interesting thing is that this early rather disturbing quantity of Italian judgments that came down, which were collected. So maybe the reason I read quite a few of them is at the time, the something called the Lca Yearbook in The Hague had a good correspondent in Italy who sent them a lot of these decisions. So that's maybe why there were so many from Italy, sort of rivaling other countries where there was a lot of activity, such as the United Kingdom and the United States. The situation was rescued once this got to the Court of Appeals. And I think anyone reading Italian decisions now in the large scope of time will come to the conclusion that Italy loyally supports the international rule in the work of its judges. And why do they do this? I think the understanding is, it's very simple. Sometimes Italian parties win arbitrations against foreigners, and they would like their legitimate, the legitimate upholding of their contractual rights to be effectively recognized, which might, in a circumstance similar to the one I've just described to you, involve the enforcement of an award in the country of a foreign defendant, where the local judge might also think that this award is pretty weird and something that is unsettling to that single judge. So one might say a wider understanding of the reasons why Italy accepted to be bound, or why any country would accept to be bound by this treaty, prevailed in the sense that it is generally of interest to Italy. Parliament wasn't crazy when it accepted the convention. It is generally of interest to Italy, which is a country whose industries are very active internationally in trade, that international contracts and international contract disputes are are handled in a way that people can rely on the contracts which they have signed and where they are the deserving party in the view of a neutral tribunal. So that's the way you can explain. After all, you can love a child that isn't all that beautiful. And it is very important, because if the only thing you do is respect beautiful awards written the way you would have written them in favor of parties that you favor, having practical effects that suit your community, then we're lost and the system isn't going to work at all. International arbitration has been very successful, and when any human institution is very successful in the sense of being used very widely, there will be difficulties and there will be controversies and there will be misadventures. So it's not so odd to notice that there are some very positive developments and other developments which one might call difficulties which remain on the road and which we have to think about. First of all, the good news. I think as time has passed, the participants in the international arbitral process around the world have become much more diverse than they were when I started in practice. The participants, not just the parties sort of suffering the consequences of their agreement to arbitrate, but those who work in the arbitral institutions that supervise arbitration, lawyers who present cases on behalf of parties, and of course arbitrators who decide cases. It used to be that there were some privileged nationalities which seemed to be the ones who really knew this process, which was confusing and to everybody else, who therefore felt a bit lost and a bit defensive about it. Well, those days happily are gone. It's made it much more enjoyable to participate in the process because it is a rich and diverse population where you can meet friends and make friends who come from a great variety of places and who can teach you an awful lot. And that is much better than just talking to your own little community all the time. I think for students, I say, you might not realize, in international terms, it may seem like not such a big deal, but in the little slice of human population which is involved in international commercial law and the resolution of disputes in international commercial law, the experience of the vis moot is internationally, sociologically significant. The number of students who go to Vienna every year, hundreds and hundreds of them every year, find that they are able to work and compete successfully with students from all over the world and resolve problems arising out of an international contract, which, to make it more cosmopolitan, is not subject to a particular weird national law, but which is to be decided under the International Convention on the Law of Sales. So there's one text. So everybody has to use the same code and try to, which is not a national code, and try to interpret the terms of that instrument and then apply them to given facts and argue their case. And they find the ones who are diligent and who have a gift for legal reasoning, find that they can compete perfectly well. And I think in no time at all, this has been a huge thing, and they then go home to their countries where they tend to become leaders in the bar of people who practice in the international arena. and they become players. That breaks down the resistance to the international process, thinking, oh, this is for foreigners. This is so important. And I have a feeling most of you listening to me today, and maybe all of you, will understand the sentence which I will now utter. It is indispensable that the word international doesn't mean foreign. International is us. Every one of us has as much right as anybody else to say that we are participants in the international community, because that's the community of which we are members when we operate internationally. It is absolutely essential. In the early days of international commercial arbitration, well, I'm telling you, international arbitration was thought of that foreign thing. What is this foreign thing? Think of the ugly award coming to the Italian arbitrator. Who are these foreigners doing this to my good citizens down the street? It's a sea change. It is fundamental. It is important always that this be the idea. International is us. And when there's something wrong about it, we don't complain about it. We do something about it, and we raise our voices and we try to reform it, and we have as much right as anybody else, all of us, to make our voices heard. The leading arbitral institution in the world for commercial matters has, for 100 years, been the International Chamber of Commerce in Paris. To survive and to thrive, any arbitral institution has to be in a process of continually considering reform and adapting to the environment in which it operates. As a result, the International Chamber of Commerce Court of Arbitration, which early on was really pretty much a West European affair with North America, well, Canada and the United States. That was sort of pretty much the ICC. It was the world's leading arbitral institution, and so non-Europeans, non-North Americans would be led to accept clauses calling for arbitration by the ICC, and then discover that it was something which was pretty European. And to some extent, there still are some people who assume that it continues to be so. And maybe some of them are very happy that this is so, because they themselves are European or lawyers working in-house for European or American multinational arbitrations, and will say, yes, we always go with the ICC. We trust them, because they're us. Well, they haven't looked recently at the governing structures of the ICC, which have gone with the times. And it's been a long time, I tell you, since the members of the Court of Arbitration, not the arbitral tribunals individually, which I'm sure you all know are chosen individually on a case-by-case basis, but the supervising court that supervises not individual cases, but the rules and the organization as a whole, the members of the board, it's been a long, long time since that board was comprised of a majority of Europeans. And if you actually look at it and you're working for a European corporation, assuming these are friends of yours, you will see that they may or may not be friends of yours, but not because they come from all over the world, and sometimes it's been a strong majority of people from emerging states in the world. That's all as it should be. And so that's sort of the good news of the diversification of the participants in the process and the community which is being created. Now, the bad news, or the things that raise problems, is that notwithstanding the advances made in the field, that there are occasionally extremely unhappy parties who will mobilize support for their attacks on the process. And sometimes these parties are not wrong. in the sense that in a particular case that they had the misfortune to be involved in, something did go wrong. Since that probably, unfortunately, is a very large case, it embitters them against the entire process just based on that one example, even though it may not be typical. And arbitration suffers as a result. And things are said about arbitration. There are some bitter experiences. And this, I will tell you, is not only true for those who participate in international arbitrations who come from small countries or countries where they don't have a rich local bar in terms of population, which is experienced in international cases. No, there have recently been, just the country where I spent most of my career, which is in France, there was one great misadventure in an arbitral case, which wasn't even international. It was an internal French arbitration with 3 French arbitrators, and something went terribly wrong, calling into question the ethical comportment of arbitrators in that particular case, which got the attention of the French parliament and actually the French prosecutors and criminal proceedings against the people who were involved. And that, of course, calls our attention to the fact that nothing is perfect, and even things that come close to being perfect can run into individual instances of abuse and wrongdoing that you should not try to hide, that you should deal with and try to ensure what can be repaired will be repaired, and certainly that that will not happen again, and learning from experience. The one great difficulty has to do with the possibility of influence peddling. I think this is a greater problem than corruption. Corruption is a very rare thing in my experience, and I've been doing nothing but international arbitration for 40 years. But influence peddling in a broader sense is something which raises its head from time to time. Even the suspicion of that one party for somehow has preponderant influence over the arbitrators, over their decision-making process, over the favoritism they might show to particular witnesses, to a particular theory, to particular lawyers, what have you. That is something which one must consider at all times. And it is something which is a concern, and I will come back to that when I deal with the topic of unilateral appointment of arbitrators. But first, I'll say a few words about institutions. Institutions, of course, have to be very conscious of the indispensable nature of ethical probity in the way they handle cases, appoint arbitrators, supervise the work that arbitrators do to the extent that they have the authority to do so. Here, I think we know what is necessary. There are too many international arbitral institutions in the world. I can promise you that. A Brazilian friend once told me that there were more than 100 international arbitral institutions in Brazil. I assume a couple of them were created by 2 men and a dog, hoping that somehow they would attract cases and they could be the arbitrators. I don't know. It sounds like, well, obviously it's sheer madness to think that one country could have so many international institutions. And actually, when you look at them, they seem very local. And the word international is a misnomer. So we focus on the serious entrance. To offer yourself as an international arbitral institution, so you have to be cosmopolitan. You have to have diversity in the way you constitute your environment. And here, I think we can point to some things that are obvious, and I don't need to belabor. But in terms of the categories of what needs to be watched for, that is transparency, obviously, the way the place operates, how people are named to decision-making positions, how the rules are changed, who are the people who are involved in making changes, and how do they account for it, and can you have information about the way the place operates? That's probably the first thing. Inclusiveness, I've already touched on that before. We see that the institutions that succeed today internationally are the ones who have made themselves inclusive, and when they don't, they tend to wither away. They have to avoid entrenchment. Now, this is not all that often thought about, but if you have people doing a pretty good job in a particular function, the tendency might be that they stay there for too long. And therefore, they engage in repetitive patterns of behavior, which are resistant to reform. This is how we always do it, and we continue to do it. As I said, there are challenges internationally, and you have to reform as you perceive that there are things to be improved. And if you have a population of officials who are too entrenched and just stay there year after year, decade after decade, that's probably something to watch out for. And the final thing, for those of you who study regulatory law, there's the possibility of capture as well. When individuals work for institutions and then go to work for those who participate in the process. This is not a major point, but it's obviously that's the kind of thing that has to be watched out for, because to the extent that there is confidentiality, those who work for institutions have to be somewhat reserved in the way they talk about their work when they're dealing with friends who have the same background as they do, and might now be in a position where they want to get sort of an inside scoop on something that's happening, which might not be harmful or prejudicial, but sends wrong signals to the extent that this is known. Now, I wanted to say a few words about the issue of the unilateral appointment of arbitrators. And here, when I talk about this problem, and my audience is comprised of young students, and I suggest what my preferred outcome is, I'm always applauded. So I like to speak to young audiences because they're always with me. When I speak to old lawyers, they tend to be 90% against me, but I think it's because they misunderstand me, or because they're so afraid of the idea that well, I put it this way. I think my argument is so powerful that those who resist it mischaracterize it, because it's easier to fight against it that way. Let me tell you what this is all about. I worked as the president of the London Court of International Arbitration for 7 years. And that was a very interesting experience and a very good one. I liked that organization very much. And I liked working with the young staff members. Young staff members of arbitral institutions, I think invariably strike me as very hardworking and idealistic and very proud of their institution, and a bit competitive. You know, they want their institution to be the best, and therefore, by definition, better than the next one, or all the next ones. And that's all right. You should strive to be the very best. And so it was a pleasure to work with young lawyers who were discovering arbitration and now actually working on the inside and doing the hard anonymous work of channeling arbitrations through the process of reaching an award. So I was walking in the halls of the LCA one day, and I overheard two young staff lawyers talking about an award. And one said to the other one, "Did you see the award in such and such case?" And he says, "Yes, I saw it. It was such a great award. It's just really nice when our arbitrators come out with something as good as that." And I said, "Hold on a second. I just heard what you said. And I want to know, what is it about an award that you think is so great?" And they said three things. I'm tempted to ask if anybody wants to guess, but it'll take too long because there'll be lots of good guesses, I'm sure. Three things. said, well, the award came out on time. And I thought, well, if an award doesn't come out on time, who do the parties call and shoo out and say, come on, where's the award? Get it going. Well, you don't call the arbitrators because after all, they're still deciding your case and you don't want to offend them. So you call the poor staff member of the institution and yell at them and say, where's my damn award? So not surprising, they like awards that come out on time. Second, on budget, the arbitrators did not ask for an addition to the deposit on account of their fees. Well, that sounds good to me too, and you understand why this comes from staff members of an institution. Who do you think the parties call and complain to if the arbitrators ask for more money? Not to the arbitrators, that's sort of delicate. After all, they're still going to decide your case. Same point. You call the staff members and you know they're blameless in all this, and you say, what in the world's going on? What's the third one? It's the big one. It makes sense. And I thought about that a long time. These are young lawyers, and they're, you know, it's sort of competitive to get a job at these institutions, and they're proud of their institution, and they read an award, and the award makes sense. Now, why would an award not make sense? An award might not make sense if there's sort of a funny compromise, because the presiding arbitrator wants to achieve unanimity on the tribunal and therefore fudges it a little bit, and you don't get a robust decision. And the thing is a bit equivocal when it really needn't be. And it's sort of disturbing. Anyway, those were the three things that young staff members found to be, and it made an impression on me. And I thought about it, and the next day, having thought about it some more, I'd said, tell me again, what case was that? And who were the arbitrators? And they told me, and I said, well, isn't that the case where all the three arbitrators were appointed by the institution? And they said, how did you know that? So I'm just wondering. And they said, yes, it was. And from that moment on, I made it my business to look at all the decisions that were rendered by arbitrators, all named by the institution, and none named individually by one party. And I will reveal to nobody's surprise, I hope, that those decisions tended to come down on time, within the budget, and awards that made sense. Now, we can talk all day long about why that is so, but maybe some of you will not be all that surprised. As a result of that, I came up with the idea that there was a problem with unilateral appointments of arbitrators, and sort of being there being the possibility or the suspicion of a bit of a trade-off among arbitrators in order to achieve unanimity. And that wasn't necessarily a good thing, because that insinuates into the process some degree of a lesser type of justice than what you would get in a purely neutral court. So it occurred to me then, so here is where people misstate my argument. This is the older generation. They say, oh, that Paulson, he wants to forbid party-appointed arbitrators. Well, I don't like to forbid anything at all. If you want to have arbitrations where you can name relatives of yours as arbitrators, it's fine with me, as long as everybody knows what you're doing. And I'm not sure you should call that arbitration. You might run afoul of state judges who won't like it. But as far as I'm concerned, if both parties want to do it, I'm all for freedom. But as to what is a good idea, I'm not sure that's a good idea. So I wasn't wanting to forbid anything. I was just calling attention to a particularity in the LCAA rules, which I hope you will remember. The LCAA rules at the time, I think it may still be the case, said as follows: every other article in the rules say, comma, unless the parties specify otherwise. In other words, if the parties want to alter the rules in some way, they can do that. So it says, so here is the rule about how an arbitral tribunal is constituted. The rule says the tribunal should be constituted by one arbitrator named by the LCA, unless specified otherwise. So they could specify that the parties should try to name it. The second fallback is if the parties have specified that it shall be 3 arbitrators, the arbitrators shall be named by the LCA. Again, so in both cases, named by the LCA, unless specified otherwise. And then it provides for what happens if the parties specify that the arbitrators shall be named, 2 arbitrators shall be named by the parties, then it provides for that as a possibility. So the default rule, even in important cases, one assumes where there are 3 arbitrators, the default rule is that all 3 arbitrators are named by the institution. My modest idea, instead of forbidding people, was just to say, wouldn't it be an intelligent idea to keep that default rule? The day an arbitration arises, if the parties at that stage have a terrible relationship, a fractious relationship, don't insult each other, lie to each other, are totally unscrupulous about the fact that the other party is wrong and I will do anything it takes to win this case. Well, if that is the situation, you'll be very happy that the most objecting party doesn't get to appoint an arbitrator who might really not be somebody who venerates the process, but will operate as an agent of that party for the purposes of sabotage. I mean, that simply won't happen if you have the default rule. If, on the other hand, it turns out you're the claiming party and you're contemplating an arbitration, and the answer has come in, the default rule is that all 3 arbitrators will be named by the institution, but the response comes in, and the other side is represented by counsel who you know or who have heard about, and there is nothing, there's no attempt to sabotage the arbitration. You know these people, the way they answer is there is a genuine dispute, nothing seems to be in bad faith, and you feel comfortable. The first thing you might do is to pick up the phone, or your opponent might pick up the phone and call you and says, "Hey, have you looked at these rules? Have you seen the default rule is that all 3 arbitrators are named by the institution? That's crazy. Why don't we agree now? Why don't we agree now that each of us gets to appoint an arbitrator? Subject, obviously, to being excluded if there's a conflict of interest or something like that." And that can happen unless the parties agree otherwise. That then happens. My understanding, I haven't checked this for a long time, but my understanding from my recollections is that this is usually what happened in the LCIA. One party would call the other and say, I don't really like this idea that all 3 will be named by the LCA. And, I know we're having a tough fight here, but I know that you're acting in good faith. And why don't we change this? And in most instances, that was an agreement then. But having that fallback rule tends to discipline people and cause them to behave in a different way. And I think that is a good way of combating influence peddling in the process. Chuck, those are the reflections I had on the observations I've had on the challenges of arbitration and where it's been going over the last few decades. And so I propose to come to a conclusion of my causerie at this point and leave it to you to what we do next.
Thanks, John. This sort of reflection is, I think, critical for international arbitration because, speaking to the students here, unlike courts and litigation, we are the architects of the system. People like Jan have been the architects of the system, and the students at the VIS now are going to be the future architects of the system, the council, the arbitrators, the institutional folks. We're building the system, and these reflections are critical. Without any questions, I'm going to turn it over to Professor Brand to sum up. I see we're running out of time.
I'm going to take that, but first I'm going to ask a question. Because, Jan, you really piqued my imagination. You note that institutions must reform and adapt over time. But you also noted that the fundamental instrument for arbitration is the New York Convention, which was written in 1958. And so my question is, given your affinity for working with younger folks and thinking that institutions should adapt over time, what parts of the New York Convention would you change to make the child more attractive?
I think that, well, there's an easy answer, which is that there are parts of it which are continually misunderstood, which I think all of us who teach international arbitration discover that our students, as they read the convention, become confused about sometimes even the layout of the text and the generality of some expressions which could give rise to conclusions which are actually incompatible and are not clear. So sort of clarification and specificity is lacking. There are some things that I think beyond that, I think it's a very large subject, but I would point out that there are some expressions, such as the public policy exception to the enforcement of awards, which are inherently impossible to translate in a meaningful way. I don't mean a linguistic way, but to translate from what in a given culture do you mean by public policy? In a country which has a particular kind of organization, a particular way of looking at economic transactions in the market and how it operates, and the role and importance of regulatory actions by the state. But how do you find an expression which can mean something more concrete without choosing a camp where the international community is really divided on some of these things? So that has to be, that I think just simply has to work out as a matter of practice. And the practice here will probably never be uniform. And there will be a different nuance in the way a Chinese court will understand public policy, for which they have an expression which sounds very different to me. Even when you put it in English, sort of a correct translation of the Chinese doesn't sound like my idea of public policy. I think we're bound to live, to have to live with that and see how it works out. But in the end, ultimately, I think there is not a clash of culture in the sense that some people are for the binding nature of arbitration and some are against. I think the clash of culture is not at all cultural. There is a divide in individual cases between people who represent claimants and people who represent defendants, and the claimants want efficient justice and the respondents want due process, sometimes till the cows come home.
Thank you. This has been a wonderful presentation. Thank you for so many thought-provoking statements in it. This is the point in a lecture where normally we are in the courtroom at the University of Pittsburgh School of Law, and we've had the applause that I've heard virtually here, and we get ready to retire to a reception where we can continue the discussion, and I wish we could do that. The other thing we normally do, that we always do, and have done 28 times in the past, and we'll do this time, but can't do in person. And I wish things had worked out and we were both in Bahrain and we could have done that, is present you with our token of appreciation for the lecture, and that is a clock. And everyone who's given the lecture has this clock, and we've tried to make it special. And what we do is, in order to represent peaceful resolution of disputes through law, in the clock will be embedded a piece of the Berlin Wall. And I've loved being able to see people after they've given the McLean lecture and see the clock in their offices, and with that indication of what this lecture is all about, and peaceful dispute resolution. And thank you so much for adding to that process. I wish we were both in Bahrain and I could hand you that clock. We will get it to you. I cannot close without thanking those who have behind the scenes made this possible. Rachel Ochoa and Nadine Hafaitha at the Center for International Legal Education, and Kim Getz, our IT guru, who makes sure that we don't have any problems with the virtual aspect of this. She's wonderful with that. But you've made the 29th McLean lecture very special. Thank you so much for joining us, if not from Bahrain, from London this time. I look forward to when I can present with the clock, or we will get it to you in one way or the other. But with that, again, thank you. And we will simply close the virtual setting and imagine all those people who are applauding a wonderful presentation.
Thank you very much.
Thank you.
And thank you to everyone who has joined us for this.